You are one Supreme Court retirement away from losing your Second Amendment rights. Not in theory, not in some distant future. Right now, in 2026, there are cases sitting on the Supreme Court's docket that will determine whether your AR-15 is legal, whether your standard capacity magazine is contraband, and whether the government can require you to beg for permission to carry outside your front door. The 6-3 conservatives majority that gave us Bruen in 2022, the ruling that finally forced courts to ground gun laws in actual history, is holding. For now. But Justice Samuel Alito is 76. Justice Clarence Thomas is 77. And the November midterms are coming. If Democrats flip the Senate, a conservative retirement under Trump could turn into a confirmation nightmare. A 5-4 liberal majority doesn't just tweak gun law. It dismantles the entire framework that protects your rights. Here's what nobody is telling you about what's already in motion and why the next 18 months may be the most important window for your Second Amendment rights in your lifetime. I know what you're thinking. The Supreme Court is conservative. We're fine. But you're not fine. Let me make this personal. First, your wallet. Legal gun ownership is a massive industry. When states ban entire categories of firearms and accessories, manufacturers leave, supplies drop, prices spike. The AR-15 you bought for $800 becomes a $1,500 item, if you can get it at all. And the moment a new court upholds those bans nationally, that investment becomes a liability. Second, your freedom. Right now, California and Washington have bans on standard capacity magazines, the kind that comes standard in nearly every modern pistol. Illinois and Connecticut are trying to ban the most popular rifle in America. These aren't fringe cases. They're active legal battles heading toward the same 9 justices who will decide whether Bruen stands or gets buried. Third, your safety. If you're a woman driving home from a night shift, if you're a mom whose nearest police station is 25 minutes away, if you live outside a major city where the cavalry isn't coming fast, then this isn't a debate about constitutional theory. This is a conversation about whether you have the right to defend your life with the best tool available. The people pushing these bans have security details, gated communities, and armed guards. They want you disarmed, and they're using the courts to do it. But before we talk about what's actually happening behind the scenes at SCOTUS, you need to understand the argument they're making, because it's stronger than most people give it credit for. Here's the most compelling argument from the gun control side, and I'm going to give it to you straight, because you need to know exactly what you're up against. The argument goes like this. The founders wrote the Second Amendment in 1791. The most powerful weapon a private citizen owned was a single-shot musket. The idea that the founders intended to protect the right to own a semi-automatic rifle with 30-round magazine is, at best, a stretch, and at worst, a dangerous fiction invented by gun lobbyists in the 1970s. To be fair, the Bruen standard creates a real challenge for modern courts. How do you find a historical analog from 1791 for a weapon that didn't exist until the 20th century? Gun control advocates argue you can't, and that requiring a historical match for every regulation makes it impossible to respond to modern threats. They say the court has frozen weapons policy in amber. That is their strongest case. It's not stupid. However, here's what they're not telling you. The Bruen decision doesn't say regulations are impossible. It says regulations must be grounded in the tradition of this country's firearm laws, not the whims of modern legislators who think they know better than 250 years of American history. And the historical record is very clear. The founders protected arms in common use. The AR-15 is the most commonly owned rifle in America. That's not an accident. That's a legal standard. Now let's talk about what's actually on the docket and why the deliberate delays at the Supreme Court are not neutral. Pay attention. This is where it gets real. The Supreme Court has been sitting on multiple landmark Second Amendment cases and doing nothing. Challenges to so-called assault weapons bans, Viramontes v. Cook County and cases from the National Association for Gun Rights have been rescheduled for conference again and again. Same with magazine capacity bans in California and Washington. The court keeps relisting. Relisting means they're discussing it internally. It also means the unconstitutional bans stay in effect while they deliberate. Every week those bans aren't struck down is another week law-abiding gun owners in those states live under laws that contradict what SCOTUS already ruled in 2022. Two major cases are already scheduled for arguments in 2026. The first involves whether marijuana users, including people in states where it's legal, can be completely stripped of their gun rights under federal law. The second challenges Hawaii's law that effectively bans concealed carry on nearly all private property, even with a valid permit. These are the test cases for how far the government can go in restricting where and who can exercise a constitutional right. If you're in a state with recreational marijuana and you own firearms, this case directly affects you. If you carry concealed and you travel, the Hawaii case sets the precedent for every state that wants to create gun-free zones out of thin air. U.S. v. Peterson asks whether the National Firearms Act registration and taxation scheme for suppressors violates the Second Amendment. Translation: can the government price a constitutional right out of existence through fees and paperwork? That's not regulation, that's a poll tax on liberty. Here's the real threat. The vacancy Justice Alito is 76. Justice Thomas is 77. If either one retires, and the Senate flips Democrat after the November midterms, Trump's nominee faces a confirmation war. The most likely outcome is a forced compromise, a moderate who becomes the deciding vote on every 2A case for the next 2 decades. They don't need to repeal Bruen. They just need one justice to reinterpret historical tradition loosely enough to let assault weapons bans, magazine limits, and licensing schemes back through the door. The window is right now, and most people have no idea. If you're finding this useful, and I think you are, hit that subscribe button right now and give this video a like. This channel exists to give you the intelligence briefing the mainstream media won't touch. Let's apply a principle-based filler to everything we just covered, because this isn't just about guns. This is about what a government is allowed to do to a right that is explicitly written into the supreme law of the land. Every gun control scheme, every registration requirement, every NFA tax stamp, every may issue permit operates on the same language. The government decides whether you get to exercise your right. That's not regulation, that's permission. And when the government controls permission, the right no longer belongs to you. It belongs to whoever's in office. Justice Thomas called it out directly. The Second Amendment has been treated as a second-class right. You don't have to prove to a government official why you need to speak. You don't need a permit to attend church. You don't pay a tax to avoid self-incrimination. But your right to bear arms, that comes with a background check, a waiting period, a registration fee, and in some states, a government official who decides whether your reason for wanting a gun is good enough. The right to self-defense is the right from which all others flow. If you can't protect your body, every other right is theoretical. Gun control advocates talk in terms of collective safety, deaths per 100,000 statistical risk. But individual rights don't bend to statistics. You don't lose your right to a fair trial because most defendants are guilty. Your right to self-defense doesn't evaporate because other people misuse firearms. Every weapons ban creates a black market. Every registration scheme drives buyers to private sales. Every manufacturer pushed out by regulatory burden gets replaced by less regulated foreign suppliers or gray market parts. The gun control agenda doesn't reduce access. It shifts access away from law-abiding citizens toward people who ignore the law. That's not public safety, that's theater. And one more thing for my fellow conservatives. Stop cheering for Republican politicians who talk 2A on the campaign trail and then quietly confirm moderate federal judges. Watch the judicial appointment record. Watch the votes on red flag law funding. The platform is not the policy. Demand both. Let me walk you through the 3 most likely dominoes in order of how fast they fall. Domino 1, the next 12 months. If the Supreme Court takes up Viramontes or the magazine capacity cases and rules narrowly or punts again, blue state legislatures read the silence as permission. Illinois expands its ban. California adds new categories. New York tightens its carry restrictions further. The Bruen standard remains technically in place, but gets hollowed out by lower courts who keep finding creative historical analogs to justify modern bans. This is already happening. Domino 2, the next 1 to 3 years, a vacancy changes everything. If the Senate flips and a conservative justice steps down, the confirmation fight becomes a war. A compromise nominee gets through. That justice becomes the deciding vote on 2A cases for the next 20 years. Bruen doesn't get overturned, it gets reinterpreted, case by case, until shall not be infringed means shall not be infringed unless the state has a reason. Domino 3, the slow burn, 5 to 10 years from now. National licensing, federal registration, mandatory liability insurance for gun ownership. All of it gets upheld. The right to bear arms technically still exists, but only for people who can navigate a bureaucratic system designed to make it expensive, slow, and conditional. It's the same strategy used against voting rights in the Jim Crow era. Don't ban it outright, just make it impossible for ordinary people to access. If they establish the legal framework today, and they're actively trying to, they will have all the tools they need tomorrow. The midterms are in November. Senate control is on the line. This isn't abstract. This is a countdown. Here's the good news. You're not helpless. You have power. First, get informed and stay informed. Know the cases. Viramontes, Duncan, Gators Custom Guns, U.S. v. Peterson's, Gardner v. Maryland. These are the battlegrounds. Bookmark SCOTUSblog.com. Follow the Second Amendment Foundation at saf.org. They currently have nearly 60 active federal cases working their way toward the Supreme Court, fighting this battle every single day. Second, use your voice where it matters most. The Senate confirms justices. Your senators vote on those confirmations. Contact them. Make them go on record. A senator who votes to confirm an anti-gun judge while claiming to be pro-2A needs to hear from you. Loudly, repeatedly, and before November. Third, share this video, not for my sake, for the sake of someone in your life who still thinks the Supreme Court has this under control. Send it to the person who says it'll never happen here, because it is happening, one conference relist at a time. And if you want to stay ahead of every ruling, every vacancy announcement, every vote that threatens your rights, subscribe right now and then head over to shesright1776.com to sign up for the newsletter and grab your free downloads full of the information you need to know. I put out the information the mainstream doesn't want you to have, in plain English, every month. So no, they aren't coming for your guns all at once. They never do. They come for your rights, one ruling at a time, quietly, patiently, and with the full power of the administrative state behind them. The question is whether you're paying attention. I'll see you next time. Bye.